Junior Civil Judge aspirants of the 2022. You are welcome, Karibu sana, to my class. Please read what I posted on the screen. Participants only.
MCQs on contract law. Good evening, namaskar, habari, za, I don't know what you've written in your African language. Wanakam, assalamu alaikum, walaikum. Professor Dr. M.S. Hussain. The other names are very small. I can see
No,
K. Sharad
all are
Babu.
the same. Sharad Babu, Motamari Sri Vidya. These are the three hosts we are there. So now I will switch on to the Kolikande Sharad Babu. I believe that you are ready. Sharad Babu, are you ready?
Yes, sir. Yes, sir.
Please continue with your first question.
Sir, first question is Section 27 of the Indian Contract Act 1872 deals with agreements in restraint of trade. According to the said section, every agreement by which any person is restrained from exercising a lawful profession, trade, or business of any kind is to that extent A. Voidable, B. Valid, C. Void, D. Invalid.
Void. C. Void.
Yes, option C is the correct answer. Void. Of course, there are some exceptions, but according to section 27, it is void. Now, second question, which statement is false according to the section 12 of ICA 1872 with regard to sound mind of a person for the purpose of making a contract? A person at the time when he makes it is capable of understanding it and of forming a rational judgment as to its effect upon his interests. B. A person who is usually of unsound mind but occasionally of sound mind may make a contract when he is of sound mind. C. A person who is usually of sound mind but occasionally of unsound mind may not make a contract when he is of sound mind. D. None of the above.
Option C. B.
Option C.
Yes, option C is the correct answer. A person who is usually of sound mind but occasionally of unsound mind may not make a contract when he is of sound mind. May make. It's now third question. So option C is the correct answer. It is the false statement. Third question. It was established that an agreement for resale price maintenance was unforceable as a matter of privity of contract in the case of A. Dunlop Pneumatic Tire Company Limited versus New Garage and Motor Company Limited. B. Dunlop Pneumatic Tire Company Limited versus Selfridge and Co. Limited. C. Dunlop Pneumatic Tire Company Limited versus Dunlop Motor Company Limited. D. All the above.
Option B is the correct answer. Dunlop Pneumatic Tire Company Limited versus Selfridge and Company Limited.
Yes, option B is the correct answer. Dunlop Pneumatic Tire Company Limited versus Selfridge and Company Limited. Now, fourth question, find the odd statement out. A. Offer and its acceptance don't constitute an agreement. B. All agreements may not create a legal obligation. C. All contracts are agreements. D. Contract is concluded and binding on the consent parties.
Option C. All contracts are agreements.
Find the odd statement out.
Option A.
B.
Yes, option A is the correct answer. Offer and its acceptance does constitute an agreement. So option A is the odd statement out.
कोई और नहीं करता.
Fifth question. In an agreement of service by which a person binds himself during the term of agreement not to take service with anyone else directly or indirectly to promote any business in direct competition with that of his employer is not in restraint of trade. So it is A, invalid agreement, B, void agreement, C, valid agreement, D, voidable agreement.
Option C is valid. Is acceptance
Yes,
to
option C is the correct answer. It is a valid agreement.
Implies not
Sixth
restraint.
question. This is an exception to the restraint of trade. Sixth question. A agrees to sell B 100 tons of oil. The agreement is A valid for certainty, B void for uncertainty, C voidable, D invalid.
A.
Option B.
option B void for uncertainty.
Yes, option B is
According
the
to
correct
section
answer. Void
29.
for uncertainty because no specific oil is mentioned as per section 29 of ICA 1872. Now, seventh question is a contract to do or not to do something. If some event collateral to such contract does or does not happen is called A quasi contract, B conditional contract, C wager, D contingent contract.
Option D. Contingent contract. Option D.
Yes, option D is the correct answer. Contingent contract. Now that is according to section 31. Eighth question. A consigns goods to B for sale and gives him instructions not to sell under a fixed price. C, being ignorant of A's instructions, enters into a contract with B to buy the goods at a price lower than the reserved price. A is bound by the contract. It is according to A, section 235, B, section 238, C, section 237, D, section 240.
Section 237.
Option B.
Option C is the correct answer, section 237. A is bound by the contract according to section 237. Ninth question. A, the captain of B ship signs bills of trading without having received on board the goods mentioned therein. The bills of lading are A, valid, B, void, C, voidable, D, invalid.
D. Voidable. C. Voidable.
B, void.
B void.
B, option B is the correct answer, void. 10th question. According to section 233 of ICA 1872, in cases where the agent is personally liable, a person dealing with him may hold A, him liable, B, his principal liable, C, both of them liable, D, any one of the above.
Both of them
Option
liable.
Both of them label.
Any
Him
one of the
liable.
above. Any one of the above means either A or B or C. He can make the agent liable, he can make the principal liable, he can make both of them also liable. That is feedback. A enters into contract with B to sell 100 bales of cotton and afterwards discovers that B was acting as agent for C. A may show either B or C or both for the prices of the cotton. Now 11th question. A who owes 500 rupees to B sells 1000 rupees worth of rice to B. A is acting as agent for C in the transaction, but B has no knowledge nor reasonable ground of suspicion that such is the case. C cannot compel B to take the rice without allowing him to set off A's debt. It is as per dash of ICA 1872. A, section 230, B. Section 231, C. Section 235, D. Section 232.
See section 235.
Option D is the correct answer. Section 232. Section 232. False question. Section 191 of ICA 1872 defines A. Agent, B. Principal, C. Subagent, D. Principal of agency.
Sub-agent.
Yes. Option C is the correct
Subagent.
answer. Subagent. Section 191 of ICA defines subagent. 13th question.
Sumalata, mute.
13th question. A consigns provisions to B at Mumbai with directions to send them immediately to C at Surat. If the provisions will not bear the journey to Surat without spoiling, then A is bound, option A. B is bound in any case to take measures to safeguard the provisions from spoiling. B. B may sell the provisions at Mumbai so that A may not incur loss. C. B is held liable for A's loss. D. None of the above.
Option A.
Option B, sir. B
Option
may
B. B may sell the provisions at Mumbai.
Yes, option B is the correct answer. B may sell the provisions at Mumbai so that his principal A may not incur loss. B is the agent, and so he can sell the provisions so that his principal, his master, may not incur loss. Option B is the correct answer. 15th question. When a contract is made by conversation on telephone, the place from where acceptance of offer is intimated to the offerer by the offeree is the place where the contract is made, was held in the case of A. Lalman Shukla versus Gauridat, B. Khalil versus Carbolic Smoke Ball, C. Bhagwan Das Govardhan Das Kedia versus Mrs. Girdhar Lal Parshottam Das, D. Satyaprabha Ghosh versus Mugni Bangar and Co. Mugniram Bangar and Co.
Option A, Lalman Shukla.
Option B. Alman Shukla Gauri.
Option C is the correct answer. Bhagwan Das Govardhan Das Kedia versus Mrs. Girdhar Lal Parshottam Das. Next, 16th question. Nandan contracts to pay to Vinod the sum of 1 lakh rupees if Suresh's house is destroyed in fire accident. The contract is A. Wagering contract, B. Contingent contract, C. Quasi contract, D. Unconscionable contract.
B.
Contingent
Contract.
Option A, sir.
Contingent.
B. Contingent contract. Yes, that is option B is the correct answer. 17th question. When a contract has been broken, if a sum is named in the contract as the amount to be paid, in case of such breach, the party complaining of the breach is entitled to A. Whether or not actual damage or loss is true, the party is entitled to receive the amount so named. B. Only when the actual loss or damage is proved which is in excess of the amount so stipulated, the party is entitled to receive the amount so stipulated. C. The party who complained of the breach is entitled to a reasonable compensation not exceeding the amount so named. D. Party is entitled to receive the amount so specified unless breach is proved.
Option B, sir.
Option B.
Loss of damages told.
Option C is the correct answer. The party who complained of the breach is entitled to a reasonable compensation, not exceeding the amount so named. 18th question. In one of the following cases, the court dismissed the case and held that there can be numerous arrangements and agreements between two individuals, but not all agreements or arrangements or contracts. A. Balfour versus Balfour. B. Harvey versus Fancy. C. Rose and Frank Company versus Crompton and Brother Limited. D. Feldhouse versus Brindley.
Option A, Belpur versus.
Option A, sir. Balfour.
Belfort versus
C,
Belfort.
sir.
As option A is the correct answer. Belfort versus Belfort. Now, 19th question is, scroll it down, sir. Scroll it up. 19th question is, in one of the following cases, the court dismissed the case and held that the reward can only be claimed when there is a contract between the parties, but when the plaintiff had no knowledge of the offer, then there is no acceptance of it, and when there is no acceptance of an offer, then there is no contract between the parties. A. Lalman Shukla versus Gauri Dutt. B. Shashi versus Naveen Sanghvi. B. Fatehchand versus Balkishan Das. D. Arun Khanna versus Sumit.
Option A, sir. Lalman Shukla versus Gauri Dutt.
Yes, option A is the correct answer. Lalman Shukla versus Gauri Dutt. Last question, that is 20th question. In one of the following cases, the court held that the offer is not a vague offer, but it is a definite offer, as the company has itself stated that while using their product, if they are infected with any disease, then they can claim, and hence the plaintiff will be given the reward of 100 rupees at that time. A. Dickinson versus Dodds. B. Powell versus Lee. C. Carlyle versus Carbolic Smoke Ball. D. Merit versus Merit.
Option C,
Option C,
Carlyle versus
Carlyle
Carbolic
versus
Smoke Ball.
Carbolic Smoke Ball.
My
Yes, option
goodness,
C is the
today
correct
the
answer.
many
Carlyle
students,
versus Carbolic Smoke Ball.
yes, many participants today gave the right answers today. Now the supplementary question for the 28th. Carlyle versus Carbolic Smoke Balls Company case law. What type of the contract it is?
Open contract.
General contract, sir. General offer.
General offer, sir.
I say
General offer,
contracts are
open to all.
different. Like adhesive contract, standard contract, special contract, unilateral contract.
Standard form of contract.
Standard
It
contract.
is a standard contract.
Standard form of
Contract.
No,
I think it is unilateral contract.
it is a unilateral contract. Unilateral. Unilateral contract. One side only they published in the newspaper stating that whoever use the lozenge and he will be free from influenza within a week or two. And it is not a puff, 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 not egg puff or mutton puff or chicken puff. Puff in the sense it is not a gossip. Number one, it is not a just a false, because they have the intention to create the legal relationship. With that, the company deposited 100 pounds in the Imperial Bank. That shows that it is not a puff. They do have the intention to create the legal relationship, and hence they want to bind it. So whoever uses it, and if we could not succeed it, or the influenza would not go out, at that instance, the money will be given to him. Is it clear?
Yes, sir.
Yes. Now the turn is Motamari. Sri Vidya, are you present?
Yes, sir.
Yes. Now
Sir, you
I'll
can
switch over to the
also
Motamari.
explain this, sir. You
Yes.
can also explain this Lalman Shukla versus Gauri that is finding a missing person.
Finding a missing person, they also advertised in the newspaper.
Yeah.
That is also unilateral contract. Shall I proceed?
Okay. Sir.
Motamari, it's your turn.
Yes, sir. First question. Wagering contract is dash, whereas a contingent contract dash. Option A, void, hash valid. Option B, valid and void. Option C, valid, voidable. Option D, voidable, valid.
Option A, void,
Option
valid.
A, void, valid.
Option A, void, valid.
Yes, option A is the correct answer. Second question, A agrees to pay B rupees 10,000 if if two straight lines should enclose a space, the agreement is
Void.
Void.
yes, which is not possible, so it is void contract. Third question, where two or more persons have made a joint promise, the promisee may, in the absence of the express agreement to the contrary, compelled to perform the whole contract. Option A, severally. Option B, jointly. Option C, jointly and severally. Option D, jointly and severally, as per the desire of the promise.
Option D.
D, joint, severally.
Yes, option D is the correct answer. Fourth question. Sir, please scroll it down.
Yeah, already. Already there you could see.
An agreement to do impossible act.
Proceed.
Okay, sir. An agreement to do impossible act in itself is option A, bad. Option B, void. Option C, valid. Option D, voidable.
Option
Option
void.
void.
D, void.
Yes. Option B is the correct answer. Fifth question. Indian Contract Act came into force on option A, 15th September 1872. Option B, 1st September 1872. Option C, 1st October 1872. Option D, 15th October 1872.
Option B.
September 18.
Yes, option B, 1st September 1872 is the correct answer. Sixth question. The person making the proposal is called the person accepting the proposal is called. The person making the proposal is called dash, and the person accepting the proposal is called option A, promiser, promisee. Option B, promisee, promiser. Option C, promiser, promisee. Option D, promisee, promiser.
Option C.
Option C, promiser,
Option
promisee.
C.
Yes, option C is the correct answer. Promiser and promisee. It's proposer and proposee. Sorry for that. Seventh question. Every promise and every set of promises forming the consideration for each other is called option A, a voidable contract. Option B, a contract. Option C, a void contract. Option D, an agreement.
An
Option
agreement.
D, an agreement.
Option D, an agreement.
D, an agreement.
Yes, option D, an agreement is the correct answer. Every promise and every set of promises forming the consideration for each other is called an agreement. Eighth question. The consent is defined as option A, two or more persons are said to consent when they agree. Option B, two or more persons are said to consent when they agree upon the same thing in the same sense. Option C, two or more persons are said to consent when they understand the same things. Option D, two or more persons are said to consent when they agree upon the same things.
Option B,
Option
two or
B.
more persons are said to be consent when they agree upon same thing in same sense.
Option B.
Option B is the correct answer.
Option B.
Option
Yes,
B.
option B is the correct answer. Yes. Ninth question. A being in debt to B, the money lender of his village contracts a fresh loan on terms which appears to be unconscionable. This will be termed as option A, fraud. Option B, coercion. Option C, undue influence. Option D, misrepresentation.
Option C.
Option
Undue
B.
influence.
Yes, option C, undue influence is the correct answer. Can someone say section of undue influence?
Section 17.
17.
Yes, section 17 is the correct answer. 10th question. A fraud or misrepresentation which did not cause the consent to a contract of the party on whom such fraud was practiced or to whom such misrepresentation was made does not render a contract. Option A, void. Option B, voidable. Option C, valid.
Option A, void.
Option B, voidable. Option D,
Option B,
voidable.
voidable.
Option B is the correct answer. Void is the correct answer. Question. The consideration may be option A past, option B present, option C future, option D all the options are correct.
All the options are
Option
D.
D. Options are correct.
Yes, option D is the correct answer. 12th question. To
Say loudly.
make a contract, A makes a contract with B. A makes a contract with B to bear his business competitor. This is an example of option A valid contract, option B illegal agreement, option C voidable contract, option D unenforceable contract.
Option A. Valid contract.
Sorry, it's illegal contract.
Undue influences is section 16 and not 17. Question number 10, I think so.
Okay, ma'am, but I think it's supplementary question. 1 minute. Thirteenth question. The Indian contract law is based on option A, English law, option B, Australian law, option C, American law, option D, French law.
English law. Option A.
English law.
Yes, option A, English law is the correct answer. Yes, ma'am. Undue influence is under section 16. Coercion is under section 15. And the fraud is under section 17. Thanks for correcting us. Yes. The 14th question. An advertisement inviting tender is option A, an invitation for negotiations, option B, a proposal, option C, an invitation for proposal, option D, a promise.
Invitation
A.
for proposal.
Option C, an invitation for proposal.
Yes, option C is the correct answer.
Yeah.
15th question. Various modes of revocation of offer has been described in option A, section 4, option B, section 5, option C, section 6, option D, section 9.
Section 5.
Option B, 5.
Are you sure regarding this?
Section 5, yes.
Yes, section. Okay, section 6, revocation how made.
Yes, section 6 is the correct answer. Revocation how made was defined in section 6. And what is section 4?
Communication when complete.
Yes, very good. Section 6?
Revocation how made.
Yes, section 9?
Promise
Regarding
is
promise
a
express
express or implied.
Yes, yes. Next question 16. Cross offer do not constitute a contract because option A, there is no acceptance, option B, there is implied acceptance, option C, crossing implies cancellation, option D, it amounts to counter offer.
Option B.
Option B. There is an impact.
No, there is
A.
no acceptance.
Option A.
Option A is the correct answer. There is no acceptance. 17th question. A contract of indemnity is a type of option A, quasi-contract, option B, wagering contract, option C, contingent contract, option D, voidable contract.
Option C, contingent contract.
Liable. Contingent contract.
Contingent contract.
No, ma'am, it's wagering contract.
Oh, yes.
18th question. Which of the following is not an essential element of agency? Option A, principal, option B, agent, option C, consideration, option D, an agent. An agreement.
C,
Option C, consideration.
Yes, option C, consideration.
Consideration.
Answer. 19th question. The contracts of indemnity, guarantee, bailment, pledge, and agency is covered by dash sections. Option A, section 1 to 75, option B, 76 to 100, option C, 124 to 128, option D, 124 to 238.
Option C, madam.
Yes, option D is the correct answer. Section 124 to 238 of Indian Contract Act. 28th question. Concerns addendum means option A, meeting of minds, option B, meeting of opinions, option C, equal rights, option D, existing condition.
Option A, meeting of minds. Option A.
Yes, option A, meeting of minds is the correct answer. 21st question. Privity of contract means option A, privacy of the terms of contract, Option B, giving priority to one party. Option C, a stranger to a contract cannot sue. Option D, interest of all parties.
Option C is
Option
stranger
C.
to a contract cannot show. Option C.
Yes, option C is the correct answer. 22nd question. All government contracts made in exercise of the executive power of the union shall be expressed to be made by the president under option A, Article 297 of the Constitution of India. Option
Are you hearing me?
23rd question. The term quid pro quo is applied in relation to option A, legality of objects. Option B, capacity of parties. Option C, free consent. Option D, consideration.
Consideration.
Yes, consideration is the correct answer.
Just a
24th
minute. You
question.
repeat the 22nd question. It is not recorded.
All government contracts made in exercise of the executive power of the union shall be expressed to be made by the president under option A, Article 297 of Constitution of India. Option B, Article 280. Option C, Article 299. Option D, none of the above. And the answer is Article 299 of the Constitution of India.
Go to the next.
24th question. Sir, shall I also read 23rd?
No. You go to the
24th.
jump.
Okay, sir. 24th question. The relationship of principal and agent may be created by option A, express appointment. Option B, the conduct or situation of the parties. Option C, necessity of the case. Option D, A or B or C.
Option D, A, B, or C.
Yes. Option D is the correct answer. 25th question. Finder of lost goods should option A, not mix with his own goods. Option B, take care of the goods. Option C, trace the true owner. Option D, all the above.
Option D,
all
all
the
the
above.
above.
She trace the true owner.
Option D is the
all the
correct
above.
answer. He need to take all things.
Yes, thank you very much, Otamari Srividya,
Thank
for
you,
your
sir.
presentation of the 25 multiple choice question, and it is my turn. My first question goes in this manner. First question, according to the dash of the Indian Contract Act 1872, there are mainly 4 conditions which have to be satisfied to form a valid contract. Option A, Section 8, B, Section 9, Option C, Section 10, Option D, Section 11. Shoot.
Option C, sir.
Option C, section 10.
I appreciate. The answer is Section 10 of the Indian Contract Act says that. Now let us see the second question. Offers get terminated by dash. Find the odd one out, which is not connected to it. A, rejection. B, lapse of time. C, refraction. D, all of the above.
E, all of the above.
Option C,
Option A,
refraction.
rejection.
Option C,
The above who
refraction.
said is wrong.
Option A, rejection.
Option C,
Rejection.
Wrong.
Option D, all of the.
Wrong.
Lapse of time.
See, I have given the feedback. Retraction, virgule, withdrawal of offer. I repeat, there should be retraction, virgule, withdrawal of offer. But I changed the retraction into the refraction. And that is odd one out. Is it clear?
Yes, sir.
Then what would be there at the C? What should be there? Right?
retraction.
Retraction, virgule, withdrawal of offer. Next question, third question. Option by performing the condition offer was observed in the case of dash. A, Moheri Bibi versus Dharmdas Ghosh. B option, Nash versus Iman. C option, Fisher versus Bell. D option, Carlyle versus Carbolic Smoke Balls Company Limited.
Option A.
Option D,
Option
sir.
B, Nash versus Iman.
Option D, Carlyle versus Carbolic Small Balls.
Carlyle versus Carbol.
Option
The
A,
right answer is D. Carlyle versus Carbonic Smoke Balls Company, where it says option by performing the condition offer was observed. What is the condition? 2 weeks we have to use the smoke balls, naphthalene balls. Okay, next fourth question. Which one is not related with the consideration? That means odd one out. A. Contract with no consideration is void. B. Maybe something value in the F law. C. Consider maybe the future past and present. It must be adequate.
Option D, sir.
D.
Option D, it must be adequate.
Then what would be the right answer?
Option D, it must be adequate.
B. Maybe something value in I of
May not be adequate. That is the odd one out. Is it clear?
Yes, sir.
Okay. A peppercorn also a good consideration. Okay? Say yes.
Yes, sir.
Fifth question. Anyone can unmute and read the fifth question? Participants?
Example of consideration all three, but not one among them. A. Money. B. Actionable right. C. Actionable claim. D. Property.
actionable right. B.
Option C.
Option B.
Option B. Actionable right.
Option B is odd man out because consideration is money, consideration actionable claim, consideration is property. Then the sixth question. Consent is free when it is not caused by dash as per the Indian Contract Act. Find the odd man out. A. Coercion. B. Option. Zero range gunpoint. C. Undue influence. D. Fraud.
Option D, sir.
Zero range gunpoint.
It is a
Zero
threatening,
range gunpoint. Option B.
but it is not there in the options. Hence, you should say zero range gunpoint is the odd man out. The seventh question. Anyone can unmute and read?
What are those four conditions to be a valid contract? Find the odd man out. Option A. Free consent of parties to the contract. Option B. Incompetent to contract. Option C. For a lawful consideration and with a lawful object. Option D. All the above.
Option D. All the
Option
above.
D, incompetent
All
contract.
of the above.
Option D.
Are you sure?
All of the above.
Free consent
Option
to
B.
parties to the contracts. Yes, it should be there. I said incompetent to contract.
Yes.
Option B, sir.
Then why you are saying D, all of the above? And some other point. A person should be competent to contract. Which section says?
11.
Section 11.
Section 11 says. What exactly the wordings of section?
Major, he's not of sound.
Competent to contract.
He's not disqualified by law.
Who are competent to contract?
Competent to contract. Who are competent to contract.
What you have to refer? Refer the Indian Majority Act for the majority.
Major.
Not sound mind. He's not disqualified by law.
Okay, agreed. Shall I proceed?
Yes, sir.
Okay, eighth question. All contracts must contain these essential elements. Find the odd man out. A. Offer. B. Agreement. C. Awareness. D. Consideration.
Awareness.
C. Awareness.
Awareness.
Wrong. I intentionally kept it there. See, when you say agreement, can you tell me?
Which is enforceable by law.
An agreement enforceable by law.
That means the odd man out is an agreement. Because you know the statement one. All agreements are contract. No, all contracts are agreements, but not all agreements are contract. Is it clear?
Yes, sir.
So odd man out is here is?
Agreements are not enforceable by law.
Yes.
Unless it is enforceable.
All contracts are agreements, but all agreements are not contracts. So can you say the agreement is the essential element?
No.
Answer no.
No.
Supplementary question. What are the 6 essential for the valid contract? What are the 6 essential for the valid contract?
Offer, acceptance, consideration, lawful object.
Competent contract.
Here I have given number 1 option offer, second acceptance, third awareness and consideration, capacity, legality. Now in this all this where the consensus of the mind will come?
Awareness.
Awareness. Thank you very much. Yes, 9th question. There are elements necessary for forming an agreement. I repeat, there are elements necessary for the forming an agreement. A. Presence of the parties plus promise. B. Consideration plus consensus parties. C. Only A and B is correct. D. All of the above is correct.
A. Presence of party promise.
I said, what are the elements necessary for the forming an agreement?
Option D, sir.
Option D.
Option D.
Only A and B is correct.
Only
A
A and B is correct.
correct.
Okay, A and B is correct.
I gave the options A, B, C, D. Which one is the right answer?
Option C, sir.
Option C is correct.
Wrong.
Option C.
I gave the option 1 A, B, C, D. You have to choose the correct answer. Why you are taking such? See, A is right, B is right, C is right.
Option A.
D, all of the above.
All of the above is the correct answer. Don't say C, only A and B is correct because I gave the option D also. So you have to give that appropriate is all of the above is the right answer for that one. 10th question. There are many types of agreements on the grounds of enforceability. Agreements, these are the types of which are mentioned. Dash. A. Void agreements. B. Valid agreements. C. Voidable agreements. D. Only A and B correct.
Option D. Option D.
As per the enforceability is concerned, agreements are only 2 types. That is
Option D.
void agreements A, B valid agreements. And hence the right answer for the here 10th question is
D. Option D.
option D is the right answer for the 10th question. Is it clear? Say yes.
Yes, sir.
Good, good. 11th question. Consensus addendum means just now Motamari Srividya also have given. But her type of asking is different. My angle is different. Consensus addendum means A. Both agreed to eat the same. B. Both agreed to like the same. C. Both agreed same thing at the same time. D. Both to taste like manner.
C, sir. Both agreed same thing and same.
Answer is both agreed same thing at the same time. That is a identity of the mind. Consensus addendum means identity of the mind. I want to sell the oil. Example given by the Motamari. Which oil? Crude oil or cooking oil or what oil? Castor oil. It is not made very much clear. I want to sell my house. Which house? He is having any 3 or 4 houses. Which house? No clarity. So consensus is addendum. 12th question. Finder of the lost goods comes under. I repeat. Finder of the lost goods comes under A. Unilateral contract. B. Wagering contract. C. Contingent contract. D. Quasi contract.
Option
D,
D,
quasi
quasi-contract.
contract.
It comes under the quasi contract. Can you tell me which section to which section deals in the Law of Contract Act? Quasi contract.
68 to 72.
Quasi contract is based on which principle?
Unjust
Oh,
enrichment.
Voice is breaking, but you are giving the right answer, but voice is breaking. It is based on English principle.
Gratuitous act.
It is based on equity principles. Equity.
Yes.
So, a person who goes to the court, he should go with the clean hands. That is the equity principles based on it. Is it clear? I don't know, the time is up, but still, because now time is 1 minute is only left over there. And regarding our studies are concerned, and shown here, where I have shown? Yeah, it is here. So the next class is
Transfer of
Transfer
Property
of
Act.
Property Act.
okay. Now I mentioned 4 cases there. Option to fulfill the conditions. Can you tell me the last you gave the answer to me? The last question answer you have given, the case law is Carlyle versus Carbolic Smoke Balls Company Limited. Then what are the other 3? Sir, you did not show the screen. No, sir. No, I have shown the screen. I read all the 3 and I read the 4th, and you caught the 4th is the right answer because option is there to fulfill the condition, that is the unilateral contract. And what are the 3 cases? I want to check your memory, sharp memory. Photographic.
Lalman Shukla
Run. Anyone?
Meher Baby versus
Moheri Bibi versus Dharmdas Ghosh, I cited the first case law. What the principle in the Moheri Bibi case law?
minor cannot.
Agreement with minor is void.
Minor agreement is void, Abhinshi.
What actually that agreement he made?
Minor agreement.
Yes, what he made? Agreement, selling the house or buying the goods?
He took a hand loan.
Property.
Mortgaged.
Yes, no, but mortgage.
Okay, next
He took
case
mortgage
law.
loan.
I cited the next case law. Quick. I want to check your memory.
Nash versus Imam something.
Nash versus Enam. Okay, let us presume that is the case law. Then what is that case law says? I already explained that case law. Yes. I already explained that case law.
That is also regarding minor.
But I told you that case law, 3-piece suit case law. S.R. Venunath has given that reply: waistcoat, blazer, coat, trouser. Tailor, 13 waistcoats are stitched over there and given to him. But it is merely he is already having it, and it is not a waistcoat is not essential, but a shirt is essential, or the coat is essential or the trouser is essential. So essentials which are not supplied over them, the tailor is not going to get any compensation. What is the Fisher versus Bell case law? This also I discussed in the class. These are all the supplementary questions. Anyone can tell me the facts of the case law? It's a famous case law. Like Dunlop Numeric Company Limited versus Selfridge Company. The privity of contract. A flick knife, button chalk, he displayed on the window. As per the Weapons Offences Act is concerned, he said, you committed an offense, but he said, I only displayed. So it is an invitation to offer, but it is not a sale. It is merely an invitation to offer, it is not a sale, and hence the definition of the sale will not attract it over there.
Balfour versus Balfour.
Fisher versus Bell. What I discussed the case law is Fisher versus Bell, not Balfour versus Balfour. I will show you. Did you see the knife here? Right hand side.
Yes, sir.
Can you anyone read it? Facts in the Fisher versus Bell. Anyone can read?
The issue in Fisher versus Bell, the defendant shopkeeper displays in his shop window a flick knife accompanied by a price ticket displayed just behind it. He was charged with offering for a sale of flick knife contrary to S.1.
What is that one? Section 1? Subsection 1? Proceed.
Of the Restriction of Offensive Weapons Act 1959.
Issue.
Issue in Fisher versus Bell.
Proceed.
The issue was whether the display of the knife constitute an offer for sale in which the defendant was guilty or any. It's too small and it's not visible.
Okay, any invitation to
trade.
In which case he was not.
Okay, what is the decision?
Can you enlarge the screen so that it can be visible to read completely?
It is directly taken from there. I can only say control.
You can enlarge it. You can increase the font size that 121. See, you can have you can see on the screen. It is 43%.
I read. Everybody mute. Everybody mute. I read. The court held that, in accordance with the general principle of contract law, the display of the knife was not an offer of sale, but merely an invitation to treat. As such, the defendant has not offered the knife for the sale within the meaning of the section 1, subsection 1 of the Act, although it was acknowledged that in ordinary language, a layman might consider the knife to be offered for sale. In legal terms, its position in the window was inviting the customer to offer to buy it. The statute must be construed in accordance with the legal meaning. That is the only invitation to treat, but not invitation to sell. It is only the displayed over the flick knife that is called Fisher versus Bell case law. And now somebody told me the Balfour versus Balfour case law. Can anyone give me the answer for what is the case law Balfour versus Balfour case law? Anyone?
Maintenance of wife and husband, it was considered to social contract.
And when I was teaching the private international law, I also teach the Balfour versus Balfour case law. And here, a husband promised to pay his wife £30 per month allowance. The wife sued her husband to enforce the promise. And here the rule of law is that agreements between the husband and wife to provide the monies are generally not contract, because generally the parties don't intend that they should be attended by the legal consequences. But when the matter comes to the private international law is concerned, if the husband promised to pay after the divorce the maintenance or the lump sum or the installment amount, at that instance, definitely the wife will file a case to the place where it is convenient to her to see that the amount would be paid. Suppose that person is staying in England and the wife is there in Ceylon, that is Sri Lanka. Yes, she can make a case in the Sri Lanka, file a case in the Sri Lanka and see that this judgment will be implemented in the England. And that's why we say that recognition and enforcement of the foreign judgment, and we will read it in the private international. So that thing, when it is a matter of the money is paid as a subsistence, so that would be the case law. It is of course a different case law. So with this, tomorrow that we are going to do the Transfer of Property Act, and be ready and read like today, where the host has finished the fourth option and you should shoot it. So with this, I would like to wind up today's class. Have a nice day. Bye.
Thank you.
Jai Hind.
Dhanyavad.
Thank you.
Thank you, sir.
Welcome.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
We live in a world full